I am Hunar Malik from the Criminal Law Review team, and I welcome you all to a panel discussion on the topic Crimes Against Women, Loopholes and How to Deal with It. Before we start, I would like to give a brief introduction of our organization. Criminal Law Review, the CRLR, was founded in January 2018. Though it was limited to criminal law when it started, it has grown into a full-fledged research organization conducting projects and aims to influence policy decisions in the field of criminal law and allied fields. As a research organization, the CRLR provides an effective platform to credible and comprehensive research that deals with the intricacies and nuances of criminal law. With this session, our organization is launching its Pan-India Legal Awareness Program, Empower Up. Under this initiative, the CrLR team and its volunteers would carry out legal awareness programs in different parts of the country. We will be starting with online sessions for schools and colleges and gradually reach to villages, towns, and cities. If you're interested in volunteering for this program, visit our website www.crlrreview.in. Now I will hand it over to Samriddhi to introduce our guest speaker for this discussion.
Hi, I'm Samriddhi. I'm another member of CrLR, and I'll be introducing the guest for the session. A guest speaker and mentor for this legal awareness program is Ms. Arpita, who did her graduation from NUJS. She has worked as a researcher with a number of universities, such as the Jindal Global University and National Law University Delhi, on issues of privacy and free speech. She has also worked on issues related to cybercrime against women and prohibition of child sexual abuse. Later, she pursued a master's degree in gender studies from Central European University, Budapest. With this, we welcome you, ma'am, and ask you to take over the session.
Hi, thanks so much for the introduction and for telling us about the organization. So I will talk about crimes against women today, which is the topic of discussion, but I want to talk about the state's role in regulating crimes against women. And I will also talk about the state's socio-political and legal history in this regard. I also want to talk a little bit about theories of nationalism in this regard and what kind of a victim the state wants to protect and what kind of a perpetrator the state is invested in demonizing, which I will get to later. I also will discuss the relevant laws that I'm sure you will find out more about through the legal awareness program. I will also discuss the Home Ministry advisory that was published a few weeks ago and the role of the police in general. So, to start off with, as I mentioned, I wanted to discuss some like socio-political and historical context. There is a specific statute I want to discuss. It's called the Abducted Persons Recovery and Restoration Act of 1949. So, in 1949, there was this act that was pretty mature for people who were from Pakistan and India and taken to who were abducted and who were forced to cross borders as a result of the partition. So this was a result of the Indo-Pakistan Agreement of November 1948. This act is because while it doesn't specifically deal with sexual assault, I think it really describes how the Indian state views sexual assault, and it is, I think, a perspective that is very common even today. So essentially, the thing you need to know about the act is that the act defined who an abducted person was, and the act laid out these like codes of conduct on how abducted persons were to be rescued and rehabilitated back to their families. So a lot of scholars and commentators, specifically Veena Das, talks about why this statute is extremely biased against women. So there are some parts of the statute of the act that are very obvious. For instance, the definition of an abducted person has a cutoff age for men, which is I think like 15 or 16. After 15 or 16, a man would not be considered to be abducted. But there is no cutoff age for women, which implied that a woman could have moved to, an Indian woman could have married a Pakistani man and moved to Pakistan of her own volition, which she would still be considered abducted for the interests of the state. This brings us to the next point, which is that through this act and through the, the way this act came about and the way the police and state forces acted, it became very evident that the Indian state was heavily invested in rescuing women who were of a certain age. This was usually women who were like 18 to 35 or something like that. And they were less interested in rescuing women who might have been minors or women of an older age, because these women would have been fertile. These women could have been brought back to India and sort of rehabilitated into this structure of the Hindu family, which I will later discuss is very important for the Indian state to function. And I will also later discuss why the Indian state doesn't criminalize certain acts like marital rape because of that. So basically, there are two things that became very evident with this act. One was, as I mentioned, that Hindu women needed to be rescued and brought back, whether they wanted to or not. As a result of this, some women might have gotten pregnant either of their own will or against their will, but a lot of them had to get forceful abortions. Also, a lot of women who had children with Pakistani men had to leave behind their children in refugee camps so that they could go back to India as like these pure women who were untainted. And these children were then, to use Veena Das's words, absorbed by the state's framework. They were absorbed into orphanages and refugee camps, so that any sign of like sexual misconduct could be officially removed in the country. That's one side of it. The other side of it is that the state was also invested in sending Muslim women back to Pakistan so that they could remove the mark of Hindu men's sexual transgression against these women, and they could restore the sort of like dignity of Hindu men. So that's about this act. Now, if you're wondering why I discuss this act at length, it's because I think that all these narratives are still very prevalent in India and in sexual abuse laws in India. So, for instance, you might have, noticed through this discussion that it seems like the honor of the family is very important in all these discussions, and the honor of the married woman is also very important. So, to quote Veena Das, one can find evidence of state intervention in maintaining the norms of honor and purity in violation of the exigencies of practical kinship. So basically, the state formulated its rescue mission on the basis of family and the state's honor. And I think that is still very prevalent if you consider the sort of laws that exist, the sort of victim that the state is interested in protecting, as opposed to the kind of victim that the state ignores. It's also very relevant if we consider what kind of perpetrators, what kind of accused sexual offenders the state wants to persecute. So, for instance, we already, as I mentioned, marital rape is not criminalized in India, which is strange considering the volume of sexual abuse laws in India. But that's because marital rape would, in the court's own words, marital rape would sort of take the Indian family foundation, which is to say that the court, the judiciary, or the state is not interested in holding certain men accountable, which is mostly, men of a certain religion or men of a certain caste. So I will go back to this sort of narrative of purity, of a pure woman and an evil man later on. Right now, I just want to briefly discuss the relevant legal provisions in India, legal provisions for sexual abuse. So you all might know about the Indian Penal Code. The Indian Penal Code has certain provisions against sexual abuse, sexual assault, and rape. So there's Section 354, which outlaws outraging modesty of a woman. There's Section 354A, which deals with sexual harassment. There's Section 354C that deals with voyeurism. There's Section 354D that deals with stalking. These three provisions were a result of the 2013 criminal law amendment. There's Section 371 and 372 that deals with minors and prostitution. There's Section 375, which deals with rape, which was also amended by that same criminal law amendment. And then there's Section 376, which deals with punishment for rape. I'm just going to mention a few more statutes that have relevant provisions that criminalize sexual abuse. It's not exhaustive, but I think these are important provisions and important statutes. So there's the Transgender Persons Protection of Rights Act of 2019. So this act has been heavily criticized by the transgender community because it goes against the Nalsa judgment of 2014 as far as self-identification is concerned. It doesn't create any provisions for employment or education for the transgender community, which is something that they have advocated for a very long time. And more importantly, the Act does have a provision that criminalizes sexual assault, but it does not specify any acts that are criminalized like the IPC does. The IPC does in a lot of detail. And also, it only stipulates a punishment of up to 2 years, whereas the IPC stipulates a punishment of 5 years. The next is the SEST Prevention of Atrocities Act. I would say similar to the previous act, it has like one provision on sexual abuse, but it doesn't specify what kinds of acts are punishable specifically. And I brought up these two statutes because I think the judiciary and the state does not acknowledge that sexual abuse for people of certain communities who fall within certain intersections of gender and caste or gender and religion, these people are probably more vulnerable to sexual abuse, and their concerns historically are more likely to be ignored by the police and by the judiciary. And so I think these statutes need to be drafted with a lot of care and with actual input from the community, which, as you might know, the Transgender Person Protection of Rights Act has been heavily criticized for its lack of involvement of the actual transgender community that it tries to help. Next is the POCSO Act, which deals with child sexual offenses. Pretty much the whole act is relevant in this regard. So the POCSO Act deals with child sexual abuse, the creation and the distribution of child sexual abuse material as well. Next is the Information Technology Act, under which sections 67, 67A, and 67B deal with they criminalize the sending of obscene material, sexually explicit material, and material that portrays children in a sexually explicit manner. Lastly, there's also the Dowry Prohibition Act, which is also relevant, and there are specific laws that relate to broadcasting that seek to limit the portrayal of women in a certain light, like the Indecent Representation of Women Prohibition Act, and the FCC guidelines also have some provisions. So that was the part about the laws. Next, I want to, as I mentioned earlier, discuss the Home Ministry Advisory published a few weeks ago. So this Home Ministry Advisory, it seems like it was published as a response to the Hathras rape case. And, from what I've seen of the advisory, I think it's severely lacking. I think it really doesn't address the issues that need to be addressed. And I think it also creates provisions, or it gives the police excessive power, which is troubling. So there are certain provisions that I just want to touch on a little bit. Specifically, there's one section on gender sensitivity training. I mean, I guess it's the intention might, or like it's supposed to achieve gender sensitivity, but strangely, there's nothing about transgender people in that section. And recently, a transgender woman was, Sangeeta, was murdered. A lot of transgender people have faced sexual abuse and abuse in general over the last couple of years, and there's been no legal recourse as such. Um, and so I think that definitely needs to be addressed if they're going to address this through the police. Next is, I also think, assuming that this was in response to the Hathras rape case, they should have definitely, from what I see, there's nothing on caste-based violence. And it is pretty well known that the Hathras rape case was a result of caste-based violence. And caste-based violence and sexual violence are not always like these separate things. So I think the advisory is lacking in that regard as well. There's they have a provision on creating a registry of sex offenders, which there's really not much about it. There's no details on how this will really be created, implemented, or how that data will be protected. So there's not much we can say about it. I want to question its effectiveness if it was implemented. Like, conviction rates are so low. People of a certain community, people of privileged communities are usually not convicted. So what is really the point of a sex offender registry if our conviction rates are so abysmal? Then there's another, the last part that I want to talk about from the advisory is, if you've gone through the advisory, you might notice that there are lots of provisions on increasing police patrolling, increasing police booths, increasing the presence of the police force wherever possible, which is, I think, very worrisome. And I will get to that in a minute, on how there is no police accountability in the country to begin with. And without that, you can't just increase the presence of the police and hope that things will go right. Just one last thing from the advisory, which I think is worrying, and it kind of allies with the kind of work I've been doing on nationalism. And that is, if you'll notice, the advisory has a section that says increasing representation of women in the police force. I think that should be worrying, because as I said, the police force structurally is not held accountable. It's, as you might notice in the Delhi riots, the police had unencumbered power, and adding women to the police force is not going to make any structural changes. And in that regard, I wanted to just briefly talk about this concept of, right-wing feminism, or femo-nationalism as it's called, which is like when theories of nationalism and theories of feminism align, and feminism, or a version of feminism, which is not what feminism is actually about, is used to bolster right-wing ideals or to bolster nationalistic tendencies. And if anyone is interested, you should look at Sarah Faris's work. She wrote a book in 2017 called "In the Name of Women's Rights: The Rise of Female Nationalism," where I think she studies the rise of right-wing nationalism in Europe, and she studies how, like, a very limited idea of gender equality and feminism is used to actually discriminate against Muslims and Muslim men. And I worry that this provision of the advisory, which is, I mean, it really doesn't do anything, but it adds gender sensitivity and increasing representation of women in the police force, as though that is supposed to appease like progressive ideals, but I don't think it actually does that. So that's something that I wanted to highlight. While we're on the topic of police accountability, I found this quote from this article that I just wanted to mention. So This is from an article on Scroll by Rohan Deshpande. It's on police accountability. So this is the quote. The Status of Policing in India report 2019 by Common Cause and the Center for the Study of Developing Societies reveals disturbing trends on police prejudice. It indicates a significant bias against Muslims. Half of the police personnel surveyed reported that Muslims are more likely to be naturally prone to committing violence. Similar prejudices existed across certain states against Adivasis, Dalits, transgender people, and migrants from other states. About 2 in 5 of the police personnel surveyed in Bihar and 1 in 5 in 6 other states had never received human rights training. Um, so that kind of bolsters my point, which is that the police have structural issues, which if you do not address, it's not going to help if you add women to the police force. More on police accountability. So the IPC does have provisions for criminal complaints against the police. But there is no procedure for an impartial investigation. So, the police can refuse to file cases against their colleagues or against themselves. Also, the Police Act of 1861, which exists, it's not a useful tool for police accountability. In this regard, it's also important to mention the Prakash Singh judgment, which mandated the creation of police complaint authorities in 2006. But according to reports, this judgment has not really been complied with, and there are very few of these authorities across the country. And towards the end, there's just a few more things that I want to discuss. This is it's not informal, but I think it's a very important aspect if we're talking about crimes against women is social media platforms and online abuse. I think social media platforms are completely unchecked in India as far as hate speech and speech, harmful speech against women and other minorities is concerned. You might have recently heard that the policy head of Facebook in India has stepped down because they were said to be influenced by the ruling party, which is also why Facebook might have so much hate speech on it, and which is also why I'm sure if anybody has used social media, you're aware of this, how platforms like Twitter and Instagram can be extremely harmful for people from minority communities and also for women. So I think there has to be a way to hold these platforms accountable for the kind of content they host. Yeah, that's about it for the laws. I just want to do a quick summary about the first thing that I was talking about, which is theories of nationalism. I think lasting change cannot happen unless we really address the cause of sexual abuse in the country, which is it's a deep rooted structural issue, and is it is tied to issues of caste and issues of religion as well. I just want to repeat that. So I mean, I have this example that I think I should use, which is that in the beginning I was talking about how there were these narratives created of a pure woman versus an evil man, and the pure woman is of a certain community and only she deserves protection, and that's why women of certain castes do not get the same kind of legal protection that other women do, and that's why men of privileged communities and men who are Hindu and upper caste are not held accountable by these authorities as much as other men are. So this is just an example to illustrate that. But you might remember the Supreme Court in 2018. There was an act called the Muslim Women Protection Act, I think, which was there was a judgment and an act, and this specifically it outlawed, it criminalized triple talaq. It made it criminal for a man to it made that form of divorce criminal. This has been this was I think welcome by most of the country. It was sort of packaged as something to do with women's empowerment and for the rights of Muslim women. But scholars who have studied this in more depth have raised questions about the actual motive behind it, because Well, first of all, the Act, and the Supreme Court states that the issue behind this Act was abandonment. It was to address an allegedly rampant problem, which is the abandonment, an allegedly rampant problem in the Muslim community, which is the abandonment of wives by their husbands. So their way of doing that was to criminalize triple talaq. So scholars say that, and this is true, in 2017, the Supreme Court had already declared triple talaq void, which means that it was not a viable form of divorce anyway. And if the state really wants to address the question of abandonment of wives, there are several more Hindu women who are abandoned by Hindu men than there are Muslim women who are abandoned by Muslim men. So why does this act, or why does the judiciary only need to intervene when it comes to Muslim women? So if you take these two facts together, one is that, triple talaq was already void. There was really no need to criminalize it. Plus, the fact that they want to address abandonment is actually not mentioned in the act at all. The act at that point does not criminalize abandonment, which means a Muslim man could actually walk out on a Muslim woman. So if you take these two facts together, which is that there's no protection, they're not trying to help Hindu women, they are criminalizing something that's already void, and they are not dealing with the issue they said they would deal with. It seems to create a narrative that they wanted to criminalize the acts of Muslim men. They wanted to create a narrative that Muslim women needed to be saved from Muslim men. And also, while completely ignoring the fact that Hindu men treat their wives in similar ways as do men of most other religions in India, based on statistics. And that really ties in with my first point, which is that the state really doesn't seem to have vested interests in all survivors of sexual abuse. They are more interested in creating a narrative that certain men are more dangerous and that certain women are more deserving of respect. Which is also why, as I mentioned earlier, marital rape is not illegal, because I'm assuming you can't, specify religion in marital rape. So, yeah, that's about it.
This is more about question and answers. So the team has come up with a few questions which we thought were pertinent and relevant to the topic that we are having the discussion. So I'll begin with a few questions and followed with after I'm done with my questions, Hunar will take over and she will address a few questions that she has come up with. So the first question is, am I audible?
Yeah.
Okay. Justice system seen any sort of improvement post the 2013 Criminal Amendment Act?
Should I answer it now, or will you guys ask all the questions and then?
We can go one by one or according to your
Okay.
convenience.
Okay, I can answer it. Yeah. So I think it's a good question. I think it's hard to measure that kind of like improvement or change. Um, like if we look at the 2013 criminal law amendment, it amended section 375. It added like stalking, voyeurism, sexual harassment, all of that. But that's just the statute. I don't really know if any change has come about in the public's perception, in the way the police functions, in the way the judiciary functions as well. I was thinking about specifically, like, if we had to consider certain metrics by which we can, um, you know, evaluate improvement. I guess we would look at news reports, statistics, things like that. But this is, I was thinking the NCRB report, I don't know if you guys have looked at the reports of the last few years, but I think at some point, maybe 2016 or 17, and I could be wrong about this, but I think it's 2016, 17. Um, the sections on crimes against women were amended, I think. So if you look at the NCRB report now, there's a so there are different like heads under which crimes against women are enumerated, and so on the status of the final report, there are three heads. There's cases ended as first report non-cognizable, final report non-cognizable, cases ended as final report false, cases ended as mistake of fact or of law or civil dispute. Now this distinction, as far as I know, was not always there in the NCRB reports. And I think it's very interesting, and maybe somebody who knows more about criminal prosecution than I do can, correct me or say something about this. But I think it's very strange that there's a heading that says cases ended as final report false, because I don't know how the NCRB can determine whether a case is false or not. To not be able to something is not the same as saying it's false. And I don't know if you guys have noticed this, but there's a there's a resurge, or there's like a lot of discourse about like false rape cases in India nowadays. And I've definitely noticed that after 2013, and I don't know if that's a result of the government like the ruling party changing, or what that is, or social media presence increasing. But I think that's something that needs to be looked at, because I think a lot of the information around like this discourse on false rape is misleading and possibly incorrect, because um, as you guys might know, like sometimes in criminal trials witnesses turn hostile, and uh, survivors of rape also turn hostile when they go on stand, from what I understand. And I think these cases are reported as false cases of rape. And so there is this narrative now that like most cases of rape are false, and that like men are being like unjustly um you know uh, like called rapists. And I don't think that's true. I think there's a very small margin of error, which happens with every law. Under every statute there are like false cases. But I just thought I'd point out that the NCRB report has that now, because in case somebody knows more about this, it would be interesting, because I don't know how the NCRB can say what is false and what is true. But yeah, I mean, so to sum up, I think we need to look at certain metrics that would tell us whether things have improved or not. And I think statistics is a huge like area. Crime statistics really need to be studied in that regard. How they've changed since 2013, how they changed after 2014, if there has been a change. So yeah.
All right, so moving on to the next question. Uh, Penalty has like certainly it has failed to create any sort of deterrence amongst the people because the conviction rate itself is quite low. So what could be done to tackle this situation, or what kind of amendments could be brought in order to make it more effective?
So I think, yeah, you're right. The death penalty is definitely not a good deterrent. It's um, statistics say that the death penalty is um, it doesn't rectify what it seeks to rectify, which is like that those crimes will be committed again. That still keeps happening. I think there are two aspects of it. One is that I think our criminal justice system does not look at rehabilitation as a form of, dealing with perpetrators. I think we're more obsessed with retribution and I think that's probably one of the biggest issues with death penalty and with sexual abuse. Secondly, which also has to do with retribution, and what I was talking about is that as a nation we're very, it seems like, obsessed with these ideas of vengeance and bloodlust when it comes to sexual abuse, because and we only feel that kind of vengeance when it comes to certain women also. I mean, maybe this is me, but I don't know if you guys remember when the Nirbhaya rape case happened, but the outrage was palpable. Like you could tell that people were outraged, but I have not seen that kind of outrage with the Hathras case, and that outrage is, I think, like a cornerstone of sexual abuse in India, is that people get really mad. There's a lot of vengeance, and I think that's why the death penalty still exists, because it like caters to that aspect of Indian society. So yeah, I mean, I think something has to be done to um, to rehabilitate perpetrators.
Okay. So the next is regarding the age of consent comes to sexual intercourse.
Mhm.
Independent court judgment, the age of consent was read down and it was made as 18. So this kind of conflicts with cases of elopement, where we see that the young woman who reaches the age of discretion, she is exercising her agency and she chooses a partner and she goes away. And those are the instances where the police chooses to treat that particular instance as marital rape. But however, marital rape otherwise is largely treated as non-existent because the law does not recognize it. So age is chosen as a factor for determining whether marital rape has happened or not because the age of consent has been read down. So is this in any way is this arbitrary in any way?
Yeah, I mean, I definitely think it's arbitrary, because, I mean, from what I understand, the independent thought judgment changed like the age from 15 to 18, right? So, I mean, so then they recognize that there is a legal fiction, that there is this like arbitrariness in the law, which is that how can you recognize that this act is rape, but this act is not rape? So I don't know what's really stopping them from going forward and just outlawing marital rape altogether. But as I've mentioned many times, I think it's really not in the interest of the state to criminalize marital rape altogether, because the state is not interested in that kind of like um, sexual abuse. They that is not within the. I mean, that's not within what the state considers in the interest of the nation. Um, the a lot of men who have not been previously um, under the criminal justice system would have to become a part of the criminal justice system then, and that is not something that the state, I think, is interested in. Yeah, I think, I mean, there's also obviously questions of bodily integrity, and how is it that um, rape as itself is identified, and the IPC is otherwise extremely detailed now when it comes to sexual acts and when it comes to sexual assault. But I mean, how is it that marital rape is not considered is a strange, it's a strange thing to me. The only answer is that the family unit is the most important thing for the state, and a certain type of family unit. As I mentioned, that's why I mentioned that act in the beginning, because the purity of that family unit is the most important thing. And so if they criminalize marital rape, then that family unit will dissolve according to them. So yeah.
Okay, this is the last question from my end, and then Hunar will take over. This is regarding the MTP Act. It's about the abortion law. So, in rape case, usually the victim has to take permission from the court with regards to whether the abortion should be allowed or not. And many a times, due to the procedural delay, because the trial gets extended, the 20-week period prescribed by the MPT Act exceeds, and because of which the woman reaches such a stage that it would be detrimental to her health if the abortion is performed. So such administrative latches have, in the current act, the administrative latches are not recognized by the law. So should the law recognize such changes and relax the period when it comes to rape victims?
Yeah, I think definitely. As you mentioned, it is because of the state's own it's because of judicial delay that there is delay in these cases anyway. But also, like the biggest issue is that it seems really difficult to comprehend why a survivor of rape would need to ask the court for permission to get an abortion. Um, I mean, there's something about if the I think there is a provision or there's a mandate that if the woman getting an abortion has survived rape, then she has to show DNA proof of the conceptors, which is like the embryo, um, to in order to get permission to get an abortion, which I think is should definitely that law should change. I don't think there should be. Um, I don't think people should have to ask the court for permission of what they want to do with their own bodies. It seems like a very strange thing to regulate, and it just really like everything about this re- reminds me of these theories of nationalism and like the state becoming the patriarch. Literally, it's literally like having to ask a parent for permission to do something. And I think yeah, I think that it's very obviously um, something that the law should change. Yeah.
Good evening, ma'am. I have three questions primarily. The first one being, even if a strong groundwork for the persecution of perpetrators of crimes against women is laid down, what are the existing provisions that we have for rehabilitation of victims? What do you think are some possible ways in which we can improve them?
So, there's the victims' compensation scheme that I think that, I mean, there are state-wise victims compensation schemes, and from what I know about the workings, and I don't know the inner workings of it, these schemes are also under a lot of dispute because it's reported that the amount of money given out is not always just, and that to begin with, this is not a way of recompensating a victim or like rehabilitating a victim of a survivor of rape. Yeah, I think to be honest, this is where legal awareness comes in because you know we know about secondary victimization. We know we know about these theories of like when a survivor of rape goes to the police, they are victimized again. It's like having to relive the situation. When they go to court, they have to um, deal with that stigma and the judgment again. And um, rehabilitation has to have the state has to find a way to rehabilitate victims so that they can um, avoid these situations, whether that is at the level of the state or the level of the family. And this is where legal awareness comes in, because only through legal awareness will people really understand that what they're doing is not going to help curtail the problem of sexual abuse. It is not the victim's fault. It's not the survivor's fault. Sorry. And only through like legal awareness at the level of the family, at the level of educational institutions, workplaces, will survivors really get a chance to rehabilitate, because it is really a community issue at the end of the day as well. It's not just the state's responsibility. Um, it's also something that communities need to address amongst themselves. So yeah, I think there's a strong need for mental rehabilitation, and that has several aspects to it. One of them being the need for legal awareness.
All right, ma'am. I'll move on to the next question, which is, how do you think we can make laws more inclusive and extend legal protection to transgender women or intersex people?
Right. So, as I'd mentioned, first of all, there the state or just any authority has to actually listen to what people of that community are asking for. For instance, the Transgender Persons Protection of Rights Act has been heavily banned across the board. Like, um, you know, as I don't know if I mentioned this earlier, but the Nalsa judgment of 2014, it recognizes the right to self-identification, which is that a person has a right to identify their own gender and and they do not need permission from any authority to to assign or to identify a certain gender. But the Act goes against that. The Act institutes a medical board that will determine whether a person is actually of the gender that they say they are of, which goes against the Supreme Court. It also goes against international standards of recognizing gender dysphoria, gender incongruence. The Act also, as I said, does not really fulfill the requirements of you know how crimes of sexual abuse should be treated, because there's only a 2 year it's only someone who abuses a transgender person will only have to be in jail for 2 years maximum, which is not equal to the IPC. And also, most importantly, there are many transgender activists who have been advocating for many years for reservation for transgender people. And Grace Banu, for instance, talks a lot about how reservation is the only way to create intergenerational change. I think those are her own words. And the Act also doesn't do anything in that regard. It doesn't create any reservation employment opportunity for reservations in employment or education. It doesn't even encourage that, I think. And yeah, I think at every level, the way to stop, the way to give rights to transgender women or transgender people in general is to include them in these conversations and ask them what they think will curtail these acts. As I mentioned, a transgender woman was um, recently murdered. Her name is Sangeeta, and I mean, it's safe to say that that has not received the kind of public outrage that other cases of sexual abuse do. Um, she was sexually abused and she was murdered, and I mean, I think so. I know she was murdered. Yeah, so I think it's a very basic act of you have to include the community in these conversations and actually include them, not just include people who have certain political leanings and will agree with the government. Yeah.
I'll move on to the last question now. Family courts generally try to persuade women to stay in the marriage in most cases to maintain the sanctity of the institution of marriage, something you even talked to us about in your discussion. Do you think this method of conflict resolution makes laws lax for crimes against women arising out of marital relationships? Why? Why not?
Um, I think definitely, like, if you really, like, if you were to look at all of these instances together, which is, as you mentioned, like meditation in family courts, or like how family courts function, then marital rape, then just generally, how the institution of marriage is treated, it's very evident that there is like a systemic denial of rights for women. So, at the civil court level, or even at a more informal level, women are never encouraged to speak up about these things because it will, go against the family's honor. It will disrupt the institution of marriage, which is one of the state's biggest fears, I think, is because the state will not be able to function the way does if women were allowed to raise these issues. Um, and yeah, I think I mean, it will take a lot of change at many different levels to be even, to be able to address the state of like women in India, the status of women in India. Like, yeah, I mean, this is like the fifth time I'm saying that marital rape is legal, and that it's tied into each other. Um, yeah, it's not within the state's interest to allow women to walk out of marriages, or to protect women from, or to give women the rights to leave these marriages, to leave abusive marriages as well. um, Yeah, that's about it.
Thank you so much, ma'am, for this informative session. And to our viewers, with this session we launched our legal awareness initiative, which is going to be on a pan-India basis. It's called Empower Up. To know more about this initiative, please visit our website at www.crlreview.in.